Hi, my name is George. Welcome to All About Law, a channel that, as its name suggests, will teach you everything you need to know about law. Today we will delve into different topics, such as what we mean when discussing a hybrid or mixed jurisdiction, the historical development of a mixed jurisdiction, its civil law components, common law components, customary law, its application in practice, its challenges and advantages. What do people mean when discussing a hybrid legal system or a mixed jurisdiction? A hybrid legal system or mixed jurisdiction refers to a legal system that incorporates elements from more than one tradition or methodology of law. The most common example is a system that mixes elements of civil law and common law traditions. Civil law, rooted in Roman law, is a comprehensive, codified set of legal statutes created by legislators. Common law, with origins in England, is based on precedent and case law, with judges playing a central role in shaping legal principles through their decisions in court cases. The Seychelles legal system is a prime example of a hybrid system, combining the French civil law system, the English common law, and customary laws. In such jurisdictions, lawyers and judges may draw upon different legal principles and frameworks when interpreting the law and making decisions in cases. This requires legal professionals to be adept in multiple legal traditions and to understand how they interact with each other within their jurisdiction. In the context of the Seychelles, understanding the mixed legal system is crucial for legal practitioners, as it can significantly affect legal reasoning, the applicability of laws, and the outcomes of legal proceedings. In a mixed or hybrid legal system, the coexistence of different legal traditions within a single national legal framework requires a nuanced approach to legal interpretation and application. These systems typically emerge in jurisdictions with diverse historical and cultural influences, often due to colonization, where the imposed legal system of the colonizing nation merges with the existing local laws and customs. Historical development. Seychelles' legal system is a product of its colonial history, having been both a French and a British colony. The French influence introduced the civil law system, whereas British colonial rule brought in elements of common law. The historical development of the law in the Seychelles offers a unique study of the fusion of legal traditions. Initially, under French rule, the country adopted the civil law system, which is largely codified and depends on written legislative codes. This system was first introduced through the French Napoleonic Code, which emphasized a systematic, comprehensive, and written statement of laws. With the transition to British colonial rule in the early 19th century, elements of the common law system were integrated. Unlike civil law, common law is characterized by the doctrine of judicial precedent, where the decisions of higher courts bind lower courts. This duality has led to a mixed jurisdiction in the Seychelles, where statutes are interpreted with a civil law approach, but principles such as equity, trusts, and judicial decisions follow the common law tradition. Over time, the Seychelles legal system has harmonized these two distinct strands, allowing them to coexist and complement each other, shaping a unique legal landscape that reflects the country's complex historical legacy. Civil law components. The civil law aspect of the Seychelles system is characterized by a comprehensive set of codes, including a civil code, the Seychelles Code of Civil Procedure, a commercial code, and a penal code. These codes are generally systematic, written collections of laws that apply to various aspects of legal relationships and are meant to be complete and exclusive. Legislation is the primary source of law, with the Parliament playing a pivotal role in creating and updating legal statutes. In mixed jurisdictions such as the Seychelles, the civil law component represents a foundational bedrock rooted in a tradition of codification. This system is characterized by its reliance on comprehensive legal codes, which serve as the primary source of legal authority. These codes, encompassing areas such as civil matters, commerce, and criminal law, aim to provide exhaustive legal guidance. The Civil Code, for example, systematically addresses the rights and duties of persons, property law, and the nuances of contractual and tortious relationships. The Commercial Code governs business and commercial transactions, setting out rules for trade practices, corporate conduct, and bankruptcy proceedings. The Penal Code defines offenses and prescribes penalties, ensuring legal certainty and predictability. Legislation, enacted by Parliament, plays a critical role in this system, reflecting a democratically grounded approach to lawmaking. In contrast to the common law's case-based adaptability, the civil law system prioritizes legislative clarity and statutory interpretation. Judges in a civil law jurisdiction typically serve as investigators and apply the law as written, without the obligation to follow precedent. This codified approach allows for a degree of legal coherence and stability, with lawmakers systematically addressing societal needs through comprehensive statutes. As a result, the civil law component of a mixed jurisdiction like the Seychelles provides a structured framework within which legal relationships are defined and regulated. Common law components. The common law tradition in the Seychelles influences procedural law, as well as certain areas of substantive law, such as company law, insolvency, and the law of evidence. Under the common law system, legal decisions are heavily based on precedent, meaning that past judicial decisions influence the outcomes of new cases. This body of case law evolves through the doctrine of stare decisis, which stands for the principle of adhering to established precedents. The common law component within a mixed legal system like the Seychelles is particularly influential in shaping procedural and certain substantive legal areas. It provides the jurisprudential infrastructure for the application and interpretation of laws in practice. In the Seychelles, common law principles govern the procedural conduct of litigation, the organization of courts, and the roles of legal practitioners, ensuring that legal processes are fair, consistent, and transparent. Substantive areas such as company law, insolvency, and the law of evidence are also deeply rooted in common law traditions. For instance, the Companies Ordinance of 1972 and the Insolvency Act of 2013 both govern company law. The statutory provisions of these two acts govern the principles that dictate the formation, operation, and dissolution of companies, safeguarding both shareholders' interests and public welfare. Insolvency law under the common law system offers a framework for dealing with financial distress and bankruptcy, providing mechanisms for the equitable distribution of assets and the orderly winding up of affairs. The law of evidence in common law jurisdictions is a critical area where past judicial decisions set out detailed rules on the admissibility, relevance, and weight of evidence. This ensures that the adjudication process is based on reliable and pertinent information, upholding the integrity of the legal system. Moreover, the doctrine of stare decisis under common law mandates that courts are bound by their own previous decisions and those of higher courts in the same hierarchy. This principle fosters a level of predictability and consistency in legal rulings, as lower courts follow the legal interpretations and rulings established by higher courts, thereby weaving a continuous thread through the fabric of legal reasoning over time. Customary law. In a mixed jurisdiction system, where a country like the Seychelles has been under both French and British colonial influences, customary law holds a unique and often nuanced position. Customary law comprises the unwritten traditional rules that have been developed and passed down through generations within communities. These laws typically govern personal status, family matters, inheritance, and sometimes land rights. They are inherently flexible, shaped by the social, cultural, and religious practices of the community, and are recognized for their ability to reflect and accommodate the values and expectations of the society they serve. In the context of the Seychelles, while the formal legal system is predominantly influenced by the codified civil law and the precedent-driven common law, customary law continues to play a role, particularly in areas that are not exhaustively covered by statutory law or where statutory law permits. For instance, in family law, customary practices may influence marriage ceremonies, divorce, and familial obligations. Customary inheritance laws may also come into play, particularly in rural areas where formal wills and estate planning are less common. The recognition and integration of customary law into the formal legal system can be complex, especially when it conflicts with statutory laws or fundamental rights. Courts in such mixed jurisdictions often have to balance the maintenance of traditional customs with the principles of equity, fairness, and non-discrimination that are central to both civil and common law traditions. This balance requires a sensitive and informed approach, ensuring that the application of customary law is consistent with national legal principles and international human rights standards. Application in practice. In practice, a lawyer in the Seychelles might consult the Civil Code for matters pertaining to contracts, personal status, or property. For commercial or corporate matters, the lawyer would look at both statutes and relevant case law. The courts must navigate these different sources of law and decide which principles apply in each case. In some instances, civil law principles might provide the general framework, while common law principles might offer interpretive guidance or fill gaps. In a mixed jurisdiction such as the Seychelles, the application of the law by judges and lawyers is an exercise in legal acumen and adaptability. Lawyers must be versed in both civil and common law traditions, understanding when and how to invoke the relevant statutes, codes, or case precedents. For instance, in contract law, a lawyer may reference the Civil Code for foundational principles, such as the requirements for contract formation, while also considering common law precedents that might influence the interpretation of contractual terms or the remedies for breach. Similarly, in the courtroom, judges are tasked with the complex role of integrating these diverse legal sources. They interpret statutes and codes within the civil law tradition, while also respecting the binding nature of precedents in areas influenced by common law. The judiciary must discern the applicable law, sometimes drawing from civil law to establish the legal context, and from common law to address specifics not covered by statute. In practice, this means that for any given legal question, the analysis may begin with the Civil Code's broad strokes and then narrow to the fine details provided by case law. When statutes are silent or ambiguous, common law principles can provide guidance, ensuring a comprehensive and reasoned application of justice. This dual approach allows for a rich and flexible legal practice that can respond effectively to the multifaceted needs of Seychelles society. Challenges. One of the challenges in a mixed system is legal certainty. With multiple sources of law, it can sometimes be difficult to predict how laws will be interpreted and applied. Moreover, training and practice in such a system require lawyers and judges to be versed in multiple legal traditions and languages, as the codified laws might be in one language, for example, French in Seychelles, and the case law in another, for example, English. Practicing law in a mixed jurisdiction presents a unique set of challenges that stem from the coexistence of different legal traditions. Legal certainty, an essential aspect of any legal system, can be particularly elusive in such settings. The presence of multiple sources of law, statutory codes, case law, and sometimes customary law, means that predicting judicial decisions can be complex. Lawyers and judges must navigate through potentially conflicting principles to find the most pertinent and prevailing rules for a given legal issue. Another significant challenge is the demand for dual or even multiple legal expertise. Practitioners are expected to be proficient in both the civil law and common law systems, which often encompass distinct methodologies and terminologies. This dual expertise extends to linguistic competence, as statutes and legal literature might be in different languages, reflective of the historical influences on the jurisdiction. In Seychelles, for example, lawyers and judges might need to be fluent in both French, the language in which many of their civil codes are written, and English, the language predominantly used in common law jurisdictions and in which many modern legal resources are available. Moreover, the continual evolution of both civil and common law can lead to complex interplays between new statutes, evolving case law, and established legal doctrines. Keeping abreast of changes and understanding their implications in a mixed legal environment requires constant vigilance and continuing education. This complexity can also affect legal education and training, necessitating a curriculum that equips future lawyers with the diverse skills needed to serve effectively in a mixed jurisdiction. These challenges highlight the need for a harmonious integration of the different legal traditions, clarity in statutory interpretation, and a judicious application of precedent to ensure consistency and fairness in the administration of justice. 7. Advantages. However, hybrid systems also offer flexibility. They can draw from the strengths of each tradition to develop a more responsive and comprehensive legal framework. Such systems can also be more adaptable to social changes, allowing for the modernization of one part of the legal system, like statutory law, without overhauling the entire system. In summary, a mixed jurisdiction like Seychelles relies on a sophisticated interplay between various sources of law, with legal practitioners needing to be adept in the nuances of both civil and common law traditions, as well as any relevant customary laws. This complexity requires a dynamic and well-informed legal community capable of operating within this multifaceted legal landscape. Flexibility and comprehensive legal framework. Mixed jurisdictions can merge the best elements from different legal traditions, such as civil law and common law, to create a more robust and comprehensive legal framework. This amalgamation allows the legal system to be responsive to a variety of legal issues, drawing on a broader set of precedents and statutes. Adaptability to social changes. Hybrid systems have the inherent flexibility to adapt to social and economic changes. This means that one part of the legal system, such as statutory law, can be modernized or reformed without the need to overhaul the entire system. This adaptability is crucial in a rapidly evolving society. Diverse legal sources. Mixed jurisdictions often recognize various sources of law, including customary law, which can be particularly important in regions with rich cultural traditions. This recognition ensures that the legal system is not just imposed from the top down, but is also rooted in the historical and cultural context of the jurisdiction. Innovation in legal practice. The existence of multiple legal traditions within the same jurisdiction can encourage legal practitioners to be more innovative in their problem-solving approaches. Lawyers and judges in mixed jurisdictions must be conversant with different legal principles and methodologies, which can foster a more creative legal practice. Dynamic legal education. Legal professionals in a mixed jurisdiction need to be trained in multiple legal systems. This requirement can lead to a dynamic and comprehensive legal education, equipping practitioners with a broad skill set that is applicable in various contexts. Jurisdictional appeal. Mixed jurisdictions can be attractive to international business as they provide a familiar legal environment for entities from different legal backgrounds. This can make such jurisdictions a favorable location for international trade and investment. Balanced development of law. In mixed jurisdictions, the law can develop in a balanced manner, with the judiciary and legislature able to draw on different legal traditions to address gaps or ambiguities in the law effectively. Enhanced interpretative tools. Legal practitioners have a wider array of interpretative tools at their disposal, allowing for a more nuanced application of the law to complex cases. Cross-jurisdictional competence. Practitioners are often well prepared to work across different jurisdictions, which is increasingly important in our globalized legal landscape. Customized dispute resolution. Mixed jurisdictions may offer more options for dispute resolution that align with the specific needs and expectations of the parties involved, leveraging the strengths of both adversarial and inquisitorial systems. Conclusion. To deepen their understanding of mixed jurisdictions, students can refer to a variety of reference materials that offer insights into the complexities, historical development, and comparative analysis of mixed legal systems. Here are some recommended titles. 1. Mixed Jurisdictions Worldwide. The Third Legal Family by Vernon Valentine Palmer. This book offers a comprehensive analysis of mixed legal systems worldwide, exploring their origins, development, and current practices. 2. The Worlds of the Trust by Lionel Smith. This book provides an in-depth study of trust law, a key aspect of mixed jurisdictions, comparing its application in different legal systems. 3. Comparative Law and Hybrid Legal Traditions by Eleanor Cashin Retain, Essen Arecca and Sean Patrick Donlan, editors. A collection of essays examining the interaction between legal traditions in mixed jurisdictions, providing comparative analyses. 4. Legal Traditions of the World. Sustainable Diversity in Law by H. Patrick Glenn. This book discusses the legal traditions that contribute to mixed jurisdictions, emphasizing their sustainability and diversity. 5. Mixed Legal Systems, East and West by Vernon V. Palmer and Mohammed Y. Matter, editors. This book explores the influence of Western and Eastern legal traditions in the formation of mixed legal systems, offering a broad perspective. 6. Mixed Jurisdictions Compared. Private Law in Louisiana and Scotland by Vernon V. Palmer and Elspeth Reed. A comparative study of Louisiana and Scotland, two prominent mixed jurisdictions, focusing on their private law. 7. Roman Dutch law in its South African historical context. Edward Fagan. This paper examines the civil law traditions in South Africa, highlighting their mixed nature and unique developments. 8. The Civil Law Tradition, An Introduction to the Legal Systems of Europe and Latin America, by John Henry Merriman and Raulio Perez Perdomo. Although broader in scope, this book provides essential background on the civil law tradition, a key element in many mixed jurisdictions. 9. The Mixity of the Laws of Seychelles, by Mathilda Toomey. 10. Legal meticage in a Micro-Jurisdiction, The Mixing of Common Law and Civil Law in Seychelles, by Mathilda Toomey. These books collectively offer a diverse and in-depth exploration of mixed jurisdictions, covering historical perspectives, comparative analyses, and specific case studies. They are valuable resources for students seeking to deepen their understanding of this complex and fascinating area of legal study. Thank you for your attention. I hope this lecture has provided you with a deeper understanding of the fascinating and complex world of mixed law jurisdictions. I look forward to the next lecture and any questions you might have. Do not forget to like and subscribe for more thought-provoking content on this channel. Ciao!